Hello, everybody. Okay, so right now we are waiting for the presser to start. This is regarding the little boy in the suitcase. We are just waiting for them to get ready, and it looks like they are about to start.
You guys good if I start? Or you need me to wait a second? Good morning. Thank you to everybody who came here today. We appreciate your assistance, and we're going to ask for your continued assistance in this matter, in this case today. So we're thankful for everybody that's here. This is a message that we want to get out to everybody and spread across the country. So it's a bittersweet day. Bitter because no matter what progress is made, what happens in a case, we're still dealing with the tragic death of a precious young child, and that unfortunately we can't change that. So bitter in that way, but the wheels of justice do turn, and we do make progress. And so we have information today regarding the case that we're thankful that we're able to come here with that information today and keep moving forward to answer a lot of questions and again to ask for your assistance.
Okay, guys, this is about the little boy in the suitcase that was found in April.
Sergeant Kerry Hall is the Public Information Officer for the Sellersburg Post, Indiana State Police. With me today is Tara Coates Hunt. She's the Deputy Prosecutor with the Washington County Prosecutor's Office. Again, this is a Washington County, Indiana case, and their office will be handling it, as well as the lead detective in this case, Detective Matt Busick from the Indiana State Police here in Sellersburg. Also have Sheriff Brent Miller from the Washington County with us today, and we're just thankful for the support of everybody here. Just a brief overview on this case. April 16th of this year, 2022, a young child was found deceased in a very distinctive suitcase on Holder Road in southeast Washington County near Pekin, Indiana. Holder Road is a dead-end road. It's very isolated, not heavily traveled at all. That was back on April 16th again. At that time, when we were first notified of the child being discovered, very little information was there for our units, our detectives, our officers to work with. There were no witnesses, there were no family members, there were no acquaintances that came forward with any type of information. We only had what we had there at the scene, and that was it. We had worked almost instantaneously with the National Center for Missing and Exploited Children, and any leads from that also proved unsuccessful. No matches to any child that was listed as missing. We had thousands of tips. We did have a dedicated tip line that's still open. Thousands of tips have come in over the past months. Again, this has been approximately 6 months since April 16th on that tragic morning or evening. Thousands of tips came in. Unfortunately, none of those tips were associated with this case. But we are very grateful for those tips that came in. We're grateful for the public's interest in this case, obviously wanting justice for this young boy. Again, at the time we advised that it was a approximately 5-year-old black male child who was found in that suitcase with no apparent signs of trauma. But we are thankful for all those tips that came in, and we do want the public's help, obviously, and we're thankful for their attention to this case. An autopsy was performed shortly after that, and again, there was no signs of physical trauma that we could detect. The autopsy did not detect any signs of physical trauma that was readily available or seen. The autopsy listed the cause of death as electrolyte imbalance that caused a viral gastroenteritis. Again, I'm not a doctor, so I can't explain all that, but that was the cause of death listed on the autopsy. Also, at that time, toxicology reports did not reveal anything. There was nothing in the toxicology reports that would lead us to a cause of death. From the onset, detectives and crime scene technicians and Indiana State Police laboratory personnel utilized physical evidence in hopes of discovering, determining, and locating a suspect in this case. I want to emphasize that no crime scene evidence technologies were spared in this case, in this investigation by the Indiana State Police, including those available only through federal and outside agencies. So we utilized everything we could. Anything that was a possibility was looked into, and the department was 100% behind it. You know, any type of funding or anything like that that was needed, there was nothing spared in this case. As a result of physical evidence and the investigation itself, our detectives were able to identify 2 suspects in this case, and detectives were also able to identify the deceased child. On October 14th, based on information in this investigation, the Washington County Circuit Court issued 2 felony warrants, arrest warrants, one for Dawn Elaine Coleman, 40, of Shreveport, Louisiana. Another for Dewan, and I'm not sure about the pronunciation on this, Ludi Anderson. Dewan Ludi Anderson, 37, of Atlanta, Georgia, who is the mother of the deceased child. Those felony warrants were for neglect of a dependent resulting in death, a level 1 felony, as well as obstruction of justice, a level 6 felony. As a result of the information gathered in this investigation, Detective Matt Busick, who is the lead investigator, and Detective Chris Tucker, also from the Indiana State Police Post here in Sellersburg, traveled to California. On October 19th, just a few days ago, Detective Busick located and arrested Dawn Coleman with the assistance of the San Francisco PD. This investigation is ongoing and continuing. As a result of information that's still being worked on in this investigation, the 2 also traveled to Los Angeles metro area after arresting Dawn Coleman. They were unsuccessful in locating Dewan Anderson, where they believed she could possibly be. Again, the investigation continues, and as a result of information that's gathered on Tuesday, October 25th, the Washington County Circuit Court issued an arrest warrant for murder for the mother, Dewan Anderson. Again, units were unsuccessful in locating Dewan Anderson in the Los Angeles metro area, if I did not make that clear. On Tuesday, that arrest warrant was issued for murder for Dewan Anderson. Dewan Anderson is currently at large. Again, she is the mother of the deceased. She's described as a black female, approximately 5'5", around 135 pounds. In her last known photo, which I have here courtesy of the Louisville Metro Corrections Department, she had dark brown hair at that time, short, dark, very dark brown hair. Again, this is the last known official photo that we have of her. We're going to attempt to get better photos. We believe we can get a better photo. Again, she's from Georgia, and we're going to attempt to get a better photograph of her for you. Dewan Anderson is last known to have been in the Echo Park area of Los Angeles, California. But since this investigation began, she's traveled to several locations west, including Houston, Las Vegas, Los Angeles, San Diego, and San Francisco. At this time, her whereabouts is unknown. So again, she's at large, and we're looking for the public's assistance in locating her. At this time, we can also identify, excuse me, identify the young man that was found in the suitcase. He was Cairo Amar Jordan. Cairo Amar Jordan was from Atlanta, Georgia. He was 5 years old at the time of his death. And Cairo would have turned 6 this past Monday on October 24th. Again, Cairo Amar Jordan He was 5, from Atlanta, Georgia. The Georgia the Bureau of Investigations has assisted us in this case as well. And
Hi,
they have
Tammy
been in
Lynn.
contact with his family members
Hello, Nana.
after we were able to get more confirmation that the boy was in fact Cairo, which this investigation has a lot of twists and turns, a lot of information. It may sound like it just moves methodically based on the information I read. So please know that this probable cause affidavit that we'll hand out has a lot of information. That's still just the tip of the iceberg. There's a lot of information in this case. So realize that we're still not going to be able to answer every in and out of this investigation, but we're giving you as much as we possibly can. I will give you a copy of that probable cause affidavit. That probable cause affidavit is for Coleman, who again was arrested in San Francisco just a few days ago. That's all the information I have at this time. So Ms. Coleman will be transported here to Indiana sometime within the next under 30 days. She will be here on Indiana soil to answer to those charges. Again, we need the public's help in locating the mother, Dewan Anderson. So I've shown that photo. We'll have that photo for you to go out and hopefully a better photo. But we desperately want the public's help in finding her and bringing her to justice. This whole case is all about justice for Cairo. That's the only thing this case has ever been about. So I know there's been lots of questions and why don't we do this and why don't we do that? The investigators have a lot of information and they all have their reasons, but the main reason is the integrity of this case and so that justice is served. And so even some things that may seem obviously, why wouldn't you do this? There are reasons why they can't. And if we have done some of those suggestions that come in from the public and from the media, it's very possible we wouldn't be standing here today. We would have nobody in handcuffs. We would have nobody in jail right now, bringing them back for a trial. So just understand that there's always a reason. We don't take, obviously, anything lightly at all. It's a very serious investigation. Again, the department's held nothing back on this investigation for our detectives to be able to do what they need to do. So having said that, that's all the information I have at this time. We can take a few moments maybe for a few questions. Again, I'm not going to get into specifics. I've given you a lot, and I will give you the probable cause affidavit that you can look into. Sure. Again, I'll start at the beginning. The first arrest, Dawn, G-A-W-N, Elaine, E-L-A-I-N-E, Coleman, C-O-L-E-M-A-N. She was 40, from Shreveport, Louisiana. The mother and currently at large, Dewan, D-E-J-U-A-N-E. The middle name spelling, I'm not positive on the pronunciation. The spelling is L-U-D-I-E. Last name of Anderson, common spelling A-N-D-E-R-S-O-N. 37, from Atlanta, Georgia. Cairo, Amar Jordan. C-A-I-R-O-A-M-M-A-R Jordan, J-O-R-D-A-N. And he is also from Atlanta, Georgia.
What's Dawn's relation?
Excuse me?
What is Dawn Coleman's relation?
We can't get into that right now. As far as I don't have all the specifics that we're going to get into, but not related physically that I know of, the information that I have.
Do they have any ties to this area at all? Was she in Metro Corrections?
She was, that photo was provided by Louisville Metro Corrections. She was arrested by LMPD a few weeks prior to this case beginning. So my knowledge is they were only here temporarily. I'm sure you guys will do your due diligence and look into the background. And
what was she charged with? Do you know?
I don't have that information specifically in front of me. I believe it was some type of a theft charge, but I can't say that for sure.
Have you spoken to Cairo's father?
The Georgia, yes, detectives from this agency have spoken with family members, and we also were assisted by the Georgia Bureau of Investigations.
When you arrested Dawn, what did she say about what happened?
Well, we don't get into any comments about that are made, any statements, any witness statements or suspect statements. But she was arrested. She was, interviewed as part of this investigation.
So what were they doing in Washington?
Do you want to answer that? Do you want any issues with me just giving general background on that? Yeah, they weren't from this area. They were passing through. Again, when you guys do your due diligence and investigating backgrounds, you'll probably come up with some accurate conclusions as to why they may have been in this area. That would have been about the time of if I correct me, that would have been somewhere around the time of the Kentucky Derby in the springtime, but I'm not positive on that.
Do you know if she had any other children?
I do not have any information on other siblings or family members or any children for her.
So for the two charges, the obstruction of justice and neglect of defendant resulting in death, if convicted, what's the maximum sentence?
Can you speak to that, or would you like to speak to that at all? They're both felonies. One is a level 1 felony, the other is a level 6 felony. So a level 1 felony is basically, it's the most serious other than murder, which is just listed as a felony. A level 1 felony is the most severe felony. So it's, I don't have the specifics right now as the maximum they could be sentenced to.
Have they offered any kind of suggestion or why they left the child in a suitcase?
Again, lots of information, and some information is in the probable cause affidavit. We're not going to speak to that this morning. Again, it is an ongoing investigation. We're still looking for one, but there's a lot of information that you will have access to in the probable cause affidavit. So we don't speak as an agency. It's our rule not to speak towards any statements or any motives. We don't speak to any of that.
Are both of the charges for both of the individuals the first?
The first two charges I listed, neglect and obstruction of justice, those charges stand for both. We have a murder warrant listed for Dewan Anderson, the mother.
Can you address at all why this has become a murder case?
Again, just information that's gathered. The detectives have gone through a lot of information, tons of interviews, in the last few days, lots of information to comb over and specialists to work with. So, as a whole, the information that they have makes our department and the prosecutor's office confident in a murder charge, and that's why that warrant's out there. Again, we have probable cause for that murder warrant. So PC affidavit, again, has lots of information listed. You won't have the PC affidavit for Anderson because she is not in custody. That is not a public document. But the other PC affidavit has lots of information. Again, that's just kind of the tip of the iceberg. We don't put everything, a whole case, into a PC affidavit, just what's needed to establish probable cause.
Was there any information that Cairo could have been in danger or that authorities had been called on his mother before for his safety or anything like that?
I don't, at this time, have that information, but I don't have information that's saying that that's the case.
So what's he enrolled in school?
I don't have that information at this time.
Speak about just the importance of getting the public's help. Obviously,
Right.
You all relied on tips from day one.
Right.
And just in locating, the suspect.
Right.
The child's mother.
Again, we had the special tip line. We asked for tips. We got thousands of tips. Unfortunately, none of them were successful. To my knowledge, Cairo, or to our knowledge, Cairo was never listed as a missing person. He was not listed as a missing child. Nobody ever reported him missing. So that would have helped, obviously, had that information been in a system someplace. So that's responsible. People who are responsible for his care and well-being have to do that. That's nothing we can control.
Because parts of these crimes cross state lines and the investigation obviously cross state lines, why has the state of Indiana and Washington County made a point of adjudicating this?
That's very good question. Long story short, basically, that's where the body was located, and the way the law is written, it can stand at that location. We can assume things. We may have information for different locations, but in the end, the child's body was found deceased at that location. So
Any idea where the child died? Specifically, was it in Georgia? Was it on the West Coast?
Again, we can't get into all the specifics of the case, but we can say that he was deceased, when he was located at that location.
What does justice for Cairo look like for you all who have been investigating this for 6 months? I can tell that everyone's feeling emotional in this room. What does justice look like for you?
Justice means bringing everybody who's responsible for this death here and having them stand and go through the system and be found, justice served through the court system. We want justice for Cairo. Many, many sleepless nights for our detectives and officers involved in this. It's not just our department, it's the Washington County Sheriff's Department was the first officer on scene. The gentleman who found him, the mushroom hunter, if you recall from the original news release, who found him, the whole community came together. Many of you were there for the funeral where he was laid to rest and given a proper burial and the recognition that we could and the honor that we could for him at that time. So justice, for everybody means bringing those responsible for his death before the public to stand trial.
The break in the case then was physical evidence that led first to the suspects or first to identifying Cairo?
Physical evidence, and again, I won't get into exact physical evidence, but physical evidence led to suspects. And, as the investigation continues, it all kind of snowballs or expands.
How difficult or easy was it to find Dr. Coleman and where was she contacted?
I don't have the specific location where she was located, but, our detectives, our crime scene analysts, our crime scene technicians have a lot of advanced technology and systems at their use to look in and utilize. Sometimes it's successful, sometimes it's not, but they had a lot of different technologies that they utilized. Specifically how they did that, I can't get into that, but just know that a lot of people were working on this case here, Indianapolis, all over, trying to assist in this.
Are you aware that if Cairo had, he was in his mother's custody at the time of his death?
Say that one more time.
Was he, did his mother have full custody of Cairo?
I don't have specific information on the custody, legal custody, but obviously, with the charges, we know that he was with her. So as far as who has physical, official, legal custody, I believe that could be the case, but I don't have that specific answer in front of me.
How was it becoming so difficult for you to find the mother? What happened? You went to LA and then couldn't find her.
Right. Again, sometimes, it's just like anything else, things change. They may have information that's available, and over time that information can stop. Again, we don't get into specifics of how it was done, but they obviously were able to at least attempt to track or locate after they had an identity for a certain period of time, but at a certain point that wasn't, they couldn't follow through with that anymore. It got them as close as they could. They did go to California and attempt to locate in the last known area. They were assisted by the Los Angeles Police Department there as well. Federal agencies, I need to mention that too, also assisted with this case. Not specifically at that location to my knowledge, but throughout the case, our detectives have been in close contact with different various federal agencies who have assisted. But yeah, the technologies, whatever they were at that time that they used, sometimes that's available and sometimes it's not. Sometimes things change, and something we did have is no longer a source.
Speaking to the family of Cairo, did you all get any explanation why there wasn't a missing child?
Yeah, I don't have information on that now, and I haven't spoken with the family, myself, so I'm sure there's reasons, but no, I don't have information as to
Will
why.
Cairo remain in Indiana? I know that.
That's very early for me, just for anybody to say, that's not something that I would be a part of and be able to answer, in years or time future after everything's completed. That's probably a matter for the family, but I'm not the one to make that call.
I know this case has been personal for you. There have been sleepless nights for yourself and for so many others in your department and for the community. Anyone who's a parent who is watching this, how does it feel to finally be able to take a breath and read that voicemail?
Well, we're not going to take a breath other than just, we're still in full stride on this investigation. So, yes, obviously, we've been looking, like I said at the beginning, bittersweet. Nothing's going to change the fact that Cairo is not with us, but we're very thankful for the information that we do have, and we can step forward. We've wanted from the get-go to be able to say we've identified this child and we've identified suspects, and we realize it takes time, but in the whole scheme of things, 6 months later, when we started with nothing other than what was in front of us in the woods that evening, and nobody came forward with any useful information. Not anybody's fault, but nobody could provide any information. Nobody that could provide information came forward. So they went from having nothing other than what lay there in front of them to a lot of answers in 6 months' time, and that really speaks well to our Detective Busick and our detectives and our crime scene technicians, our analysts, everybody involved.
What kind of physical evidence led to this?
Again, we don't get into specifics. You'll have information relied to you with the probable cause affidavit that will mention stuff, but we specifically don't mention that during.
You mentioned resources beyond ISP. Could you talk about at least what those resources were that may help fund?
Again, there's numerous technologies that are out there. Some are very advanced, DNA technologies, those types of things. We have the technology within the Indiana State Police for some of that, but there's even more advanced DNA technologies that were assisted by other agencies. Facial recognition technologies were utilized at one point by federal agencies. So again, multiple agencies assisted. Some of those have, especially the federal backing, they can do a lot of things that the state agency can't. So we were very thankful for that information and those abilities to help us.
Would anyone from Washington County like to address how this has impacted your community and the way that your community really adopted this unknown boy?
I mean, excuse me, I'm sorry. I can personally speak, if the sheriff wants to. I'm also from Washington County. It was my pastor who led the service, the funeral service for my church. So the community really came together and was very emotional and traumatic. We had candlelight vigils, but it's impacted the community tremendously. Why is this child here? But Sheriff, would you like to say anything?
I can only echo what you've said, Gary, about that and how that's impacted the community and everybody coming together. And we appreciate, all the hours that has been spent by the Indiana State Police and other law enforcement agencies, to identify this child and to identify suspects and to get at least one of those suspects in custody at this time. And hopefully with the help of the community, we'll be able to get the other suspect, in custody in a timely manner so that we can bring them both back here to Indiana to bring some closure to this case.
Is Don Coleman being cooperative, would you say, in this investigation?
Again, I can't get into statements or anything like that at this time. So again, you'll have information that's listed in the probable cause affidavit that may assist you in some of those questions. But yes, it's very traumatic. Again, I started to say earlier, a lot of sleepless nights, especially by the detectives involved. Detective Busick has spent numerous hours, and not just Detective Busick, but he is the lead investigator and has done an outstanding job. But all the detectives involved and the people involved in this case, so much information to comb over, to read through, to scan, to watch, hours upon hours. And obviously, the people at the scene, the events that they saw unfolded before them that evening. Sheriff Miller's deputy was the first on the scene. Very traumatic, event for him. So it's affected the community as a whole very deeply. So I don't have any more specific comments. I think that covers what we want to say here today. So again, once we're done here, I will get the copies of the probable cause affidavit to each of you. But the number one thing at this point is we have a suspect that's at large. We have a murder warrant for DeJuan Anderson, and we need the public's help. No matter where you live, anywhere in the United States, possibly, out of the country, we can use help locating her. So for Cairo, help us locate her for Cairo so justice can be served. Thank you.
I know you did this at the beginning, but just say and spell your name.
Sure. It's, Sergeant Carey Hull, Careyhuls. Thank you.
All right, you guys. So that's the end of that. So they have identified the little boy that was found in the suitcase. For those of you who are just joining, the little boy was found out in a wooded area back in April by a mushroom farmer. He came across this suitcase that had Las Vegas on it. And what was found inside was a little boy, unidentified until now. So just to give it a little bit of a wrap up, they have identified the little boy as Cairo Emar Jordan, 5 years old. The autopsy showed that he died of severe dehydration and no electrolytes in his system. There is one arrest so far. I just get my glasses on. I can't even read my own writing here. Dawn Elaine Coleman, 40 years old. It's a female. She has been arrested in San Francisco. She has been arrested in relation to this little boy's death. And there is an outstanding warrant for the mother, Dewan Lowdy Anderson, 37 years old, and she is from Atlanta, Georgia. She is a fugitive right now. She is not in custody yet. They have searched several areas trying to find her, all over the Echo Park area in California, Houston, Las Vegas, San Francisco. They've looked everywhere. So there is a felony warrant for murder out for her in the death of her son, Cairo Emar Jordan, 5 years old. So what that tells me, you guys, is that either this little baby was starved to death, not fed. In other articles that I did read, it stated in there that they believe the child was deceased before being put in the suitcase. So I don't remember, you guys, what my read said, but we will have to go back and check that out. I did put a link to it in the chat. If you scroll up, you will see the link to that read. It's right here. If you search my channel for the little boy in the suitcase, you will find it there. It was done back in April when the suitcase was found. So that's where that stands, you guys. There's going to be the arrest affidavit for Dawn Elaine Coleman, the 40-year-old female who has been arrested. There is going to be, her arrest affidavit is going to be released. So I will stay on top of that and hopefully be able to go over that also. The arrest affidavit is not available for the mother yet because she's not in custody yet. So we will be waiting for that. Okay. Let me just see here. Okay, we might as well get this out of the way first, you guys, because it's going to be really quick. I've got updates on the Lori Vallow and Chad Daybell case. Let's go over that one quickly because the next two are lengthy. So we'll just get this out of the way, and then we will go on to the Barry Morphew updates and then the Debbie Collier update. If you haven't smashed that like, please smash the like button. It is free and helps support the channel. Okay, so here is one of the last orders. If you remember when we covered the last hearing regarding Chad Daybell, there was a bunch of things that they asked for that was denied. And here is the order regarding the stay. Now, what had been going on was, because of all these motions and the defense bringing up valid points to sever the case between Chad and Lori Daybell, saying that Lori is prolonging this and that he shouldn't have to wait for his trial based on what's happening with her, etc., etc. Sorry, there's a lot of things that contribute to the defense finally getting their motion to sever, right? So what the prosecution tried to do was get the judge to order a stay on the Daybell, on Chad's case too, so they could keep the cases joint. So this is the order for the state's motion to stay Chad Daybell's case. On October 13th, 2022, during a motion hearing held in the case, the state made an oral motion for the court to enter a stay of this case pending the determination of competency to stand trial in the co-defendant's case, which is Lori. And they are currently joined for the purpose of trial. The defendant objected to the state's motion to stay the case. For the reasons stated on the record, which they did argue. The court has denied the motion to stay. So the prosecution, in trying to have this case stayed, has not worked for them. Okay, so let me... Okay, this is something else I wanted to show you guys regarding what we just seen, the presser. So let me just blow this up a bit. This is they had a big fundraiser, and they had a lot of people donate so they could bury the child. Didn't know who he was or nothing. So they had this headstone made in loving memory of a beloved little boy known but to God. So I do believe now that probably in this space here that they will now put Kyron Emar Jordan's name. 5 years old, his birth date. He would have just turned 6 this past Monday. His birthday was October 24th. So they will probably put that in, and I don't know what they're going to put in for a date of death. I think that it's going to be pretty much guesswork, probably the day that they found him. So I just thought that you guys might want to see that. So this was a lot of YouTubers and everybody that got this out there, that, you know, there was a fundraiser and a lot of donations went to be able to purchase this headstone for this little boy. So I do believe that they will now put his name in here. I just got chills. Okay, so now also Lori is in court today. As you guys know, we will not be able to see that because it's blacked out for us. I will see what information that I can get on that to see what happened. Is she competent? Is she going to proceed? What is going on with that? Because this jury trial starts January 9th. Chad Daybell has made it quite clear that he wants to proceed and go forward. So if that happens and she's not competent, then they'll have no choice but to sever. Now, like I said, there is a hearing for Lori today, so I will keep you updated. Please keep an eye on my community tab. I'll post that information there when I find out what happened in today's hearing for her. Now, on Friday, there's a motion to continue an order that's going to be heard, and it's in the Chad Daybell part of this. They may hear the motion to sever at that time because November 9th is the pretrial for their trial for both Lori and Chad. So I would assume that they would want to have a hearing on the motion to sever before November 9th. But I do see that there's also a court date for Chad on November 10th for the motion to sever. Well, if they're going to have the pretrial on the 9th, I can't see them doing all that if there's going to be a motion to sever on the 10th. So I do believe on this Friday that they will address the motion to sever. So I will be watching for that also. Now, also with that, you guys, if the judge does grant a motion to sever in the Vallow Daybell case, Chad's attorneys also filed to allow media, cameras, and streaming for us to be able to see this whole trial. The judge right now took it under advisement. He denied it for right now, but he did say that he would revisit that if the trials were severed, because it was Lori's attorneys that did not want the cameras and everything in the courtroom for the joint trial. But if they're severed and Chad is saying he wants the cameras there, then I think that we have a good chance, you guys, of being able to see that full trial, and I will be able to stream it. So we will keep a look on that. Okay, so let's see here. Which ones? Okay, so this I've already seen. Okay, so what one do you guys want to hear about next? Do you want to hear about the Debbie Collier, or do you want to jump into the Barry Morphew? I'll leave that up to you guys. Which one do you want to go over first? Because I have the both of them to go over also, because there's new things in that too. Let me know in the chat, you guys, which one you want me to do next. Debbie Collier case or the Barry Morphew. The one who gets the most votes, that's the one I'm going to do next. So I'll give you a minute. It's even right now. We got Barry Morphew and we got one for Barry Morphew, one for Debbie Collier. Debbie Collier. We're even again, you guys. Oh, we got 3 for Debbie, 1 for Barry. Now we're even again, you guys. We got 3 for Debbie and we got a whole whack for Barry. 1, 2, 3, 4, 5 for Barry. Barry. Okay, so we'll do the Barry first. Okay, so this is my brother from a different mother. I will link the link to this. Hang on. If you guys do want to check it out, here is the link to what we are going to see. This is my brother from a different mother, AK. Okay, so we're not going to listen to the whole thing, you guys, but what I am going to do, I'll put the volume up. I may have to put this down a bit when we start because I know this one should be pretty loud. Now, there was a hearing held yesterday. I'm sorry I could not do it, you guys. I had other commitments, but thankfully my brother here got it done. We're going to go over it. He gives a lot of commentary on it at the end too. So at the end, if you do want to go and hear what he has to say about this, please go over and check out his video, AK Rocks on YouTube. Okay. And I will put the link to this in the description also, but the link is in chat there. So this is when it first started, and we're going to hear, I enjoyed this, you guys. I come back and you're talking about bowel, what? Looks like a bowel movement. How's it? Okay, so Iris Eaton was finally put in her place. This judge is very firm. He is very to the law. And I do not think that this is a judge that Iris Eaton can play with like she has the previous judges. And that's what you're going to see. She is pissed off at this judge. So we're going to start at the beginning and we're going to go through some of what she says. It's almost like instead of just arguing for his stuff to be returned, she's going into the case and trying to get this judge to feel sorry for Barry, like he didn't do this. Like, you're not trying your case, woman. You want your stuff back. He wants his stuff back. Stick to that. But she does go off on a little tangent. The judge puts her in her place. Let's watch.
I want to make sure I get anyone appearing on the record who's involved directly in the case. This comes on for a motion.
Okay, can you guys hear that, or do you need me to turn it up a bit? Can you guys hear it good, or do you want me to turn it up?
And I'll be
Put one in the chat if you want me to turn it up.
and into that as soon as Mr. Morphew joins us. Mr.
Donald, Daniel Tom, or King County Sheriff's Office, Judge.
Thank you, Mr. Tom.
Okay, it's turned up full.
Daniel Tom, attorney representing the, I think, Chaffey County attorney, correct?
Right.
Yeah, representing the sheriff's office in the filing in this case. We'll get started just as soon as we have the defendant.
Your Honor, I have Mr. Morphew on the phone here. He can hear you. Let's see if he can hear you.
Mr. Morphew, can you hear the court?
Yes, I can. Sir.
Okay, well, let's get started. This comes on for a motion filed on behalf of the defendant for return of property that was seized as a result of a search warrant issued by the court in the early stages of the case. The case was dismissed without prejudice some time back, and I did review the motion filed for the return of the property, as well as the response filed by the people and the entry of the non-party motion objecting to basically the authority of the court to rule on the return of the property or possessions. Let me put to.
Okay, so you just heard there, the judge had stated, this is what we're having the hearing on, the return of the property. Okay, the judge has read through everything. He knows why it was confiscated. He knows why they're keeping it. The case was dismissed without prejudice, which means that they can bring charges back at any time. So he's going over all this. He's well aware of what happened in the previous court hearings and whatnot. Okay, so I think she peeves the judge off just a little bit here.
The rest, there's no question in this court's mind. The property in question was seized pursuant to a search warrant that was issued by the court in the early stages of the case, and certainly the court had authority to do that, as well as the court has authority to order the return of the assets, as that's the order of the case. I think the court's authority is without question, and I'm really not going to address that issue. I'd rather get to the substance. The response filed by the people, and it says basically this is an ongoing investigation. Case was dismissed without prejudice. We fully intend to pursue, we think, the primary suspect.
So see, as you can see there, the judge is letting her know that, look, we know the case was dismissed without prejudice, that this stuff was taken, and it's being kept because there's an ongoing investigation. He has made that quite clear. But watch, she's going to go off on her tangent, and she's basically trying to try the murder case that he was facing. She's trying to do a mini hearing on that and have it judged right here. And the judge isn't going to have no part of it. So,
is Mr. Morphew, and it is an active investigation. Let me turn back to the Ms. Aton. Are you going to be the spokesperson on behalf of the defendant?
I am, Your Honor, and I'm hoping the court might address our objection on the request for expanded media coverage and also the.
Okay, so here we go. She now is, like you could see, there's a whole bunch of people in here watching this, and she is peeved off that the judge is allowing everybody to see this. Watch what happens.
Sheriff's entry prior to any argument.
Well,
okay, let me just back that up a couple minutes. Okay, because she says, well, wait a minute, Judge. We had an order in the other case that there's not supposed to be any media coverage. That's basically what she's saying. Let's listen.
We think the primary suspect is Mr. Morphew, and it is an active investigation. Let me turn back to the Ms. Aton. Are you going to be the spokesperson on behalf of the defendant?
I am, Your Honor, and I'm hoping the court might address our objection on the request for expanded media coverage and also the sheriff's entry prior to any argument.
So she wants this
turned off. Of the substance of the sheriff's argument, and really don't want to deal with that because I don't think it's a real issue. As far as expanded media coverage, if the court's order stands, they're entitled to it. I didn't see any harm done by their participating, any prejudice to either party, especially Mr. Morphew. So I'm considering that addressed.
So there you go. She's trying to get him to shut down the streaming of this right now. Before she gives her argument, she wants everybody that's in the room out unless you are involved in the case. We've seen her do this in the previous trial. She wanted no more media coverage, so we weren't allowed to see anything. They even went as far to say that me and Kurt did something and was streaming it and all this stuff. She did a lot of things to keep the cameras out of the courtroom. And she was trying to do it again here, and the judge shut her down. So let's continue. She's now peeved off. You've seen her roll her eyes because the judge is not going to ban the media from streaming this.
Okay.
I want to address a reply to the response by the people that this is an ongoing investigation. And I'd like to hear your comments, please.
So again, as you've seen, sorry, he said this is an ongoing investigation, which means right there's his answer. This is an ongoing investigation. That's why they are still entitled to keep that evidence where it is. Okay. We're not going to listen to her whole argument, but I'll show you a bit of it. It's just, she's trying to try the case again in front of this judge, and he's just not going to have it.
Sure, Your Honor.
She's dumbfounded now because she's peeved off that he didn't stop the cameras.
Is presumed innocent. He's no different than any other citizen in Salida, in Chaffee County.
And as you can see, here she is. She's given her spiel like an opening statement at a trial for a murder. Get to the point, lady. You are here to have the evidence returned. She's going on, and she does. She goes on and on about the murder trial.
County or in Colorado, and he has a constitutional right to his property. But the prosecution's papers, as you read, seem to continue to decimate the fundamental right of his presumption of innocence and indicate Barry is a killer. And they just say it's a matter of more time for them to get a morsel of evidence to prove so. He was wrongly arrested and put in jail for 5 months and prosecuted to the highest level, only to be told, oh, never mind, we actually can't prove it without finding Suzanne Morphew. And now 2.5 years later, the prosecution says they don't know where Suzanne is, if she was murdered, or by who. Now, if the last 2.5 years haven't been enough to have seized Barry Morphew's property, they want to continue keeping it ad infinitum without any legal authority or basis. This has always been a de facto punishing of him without being convicted. So we properly identified the standard. Step 1, the prosecution seized hundreds of objects and documents, and we are asking of those items that 97 of them be returned to Barry Morphew. Barry Morphew only needs to make a prima facie showing that the 97 items are.
Just to let you guys know, that's not me clicking around and changing. That's Kurt.
His. The prosecution is not disputing that these 97 items are owned by Barry Morphew. Step 2, the prosecution must show by preponderance of the evidence that each and every single one of Barry's 97 items are the fruit of or connected to an illegal activity. That's it. So what does a prosecution assert the standard is? As a prosecution has done many times in the last 18 months since I've been on this case, they've acted in bad faith and parlayed false arguments and theories, making up their own rules for the.
See, here we go. She is fighting his case again. This is like a mini trial she has in her own little head there, that she thinks by saying all this stuff that happened in the trial, it doesn't matter what happened in the trial. This is not what she should be discussing right now. Whether, you know, they did things in bad faith and this and that and blah, blah, blah. It has been dismissed without prejudice. Give us your argument why he should have those things back. This is still an ongoing investigation. She knows she's not entitled to it. This is her way, in my opinion, to get in front of the camera and change people's opinion about Barry Morphew. Not going to happen, not in my books anyway. But she's more or less fighting the case again. bringing up things that have really nothing to do with what this motions hearing is about. He wants his stuff returned. Number two, he is on probation right now. He is not allowed to have any firearms to begin with. So for her to fight this right now, to me, it's a publicity stunt, and she wants to get in front of the camera and she wants to sway people's minds regarding this. And she's trying to have like a mini little trial within this hearing, and it's sickening, really.
This court to attempt to convince them to take action that supports their confirmation biased and unsupported theory and wrongful prosecution of Barry Morphew. As an example, in their response, the prosecution stated, paragraph 10, that in the past, when Mr. Morphew asked for his truck and driver's license back that were seized upon his arrest in a year and a half after Suzanne's disappearance, after he was wrongly held in jail for 5 months, and after he got a bond set at the...
Do you see what she's doing here, you guys? Like, this is almost too hard to watch. It's like, okay, well, he got his truck and his license back, so shut up. Why are you even discussing that right now? You are here to discuss getting all those firearms and laptops back. Why are you bringing up what's already been ruled on, right? To me, this is a media grab. This is her getting in front of the camera and trying to try this case in the court of public opinion and get what she thinks out there and trying to sway people's minds. That's the only thing I can see with her. And this is my personal thoughts on it. Like, lady, shut up. Watch Kurt. Watch Kurt down here as this is going on. He's getting a little annoyed too.
Proof evident presumption grave hearing, that they said that he had a compelling reason. And because of that, the people agreed to give the items back. They sound so reasonable when you read their papers, but that's fiction. The court can refer to the motion I was forced to draft and file because they unprofessionally refused. Please see D-23 filed on September 20th, 2022. There's one thing that is true in the prosecution's assertion. On September 17th, after the court set a $500,000 bond over the prosecution's objection.
See, like, none of this stuff matters, you guys. None of it. Oh, they set a $500,000 bond. He was in jail. I don't know how many times now, I've lost count, that she says he was in jail and he shouldn't have been, and he wasn't guilty. He was presumed innocent, blah, 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 blah. It's like, shut up, lady. This is not, she's trying this case. She's trying to try this case in front of this judge to gain sympathy, to get whatever. Maybe she's thinking once the judge hears this come out of her mouth that he will change the dismissed without prejudice to totally dismissed. I don't know what she's thinking she's going to gain by this. She's going through the hearings that were held, and oh my God, he had to put up $500,000. And if they would have known about this DNA, she's going to get to it. She's going to bring up the DNA. And if they would have known, then he wouldn't have been held on bond and this and that. Like, it just goes on and on. It's like she's trying the case here instead of just speaking about her motion to get his stuff back.
And request for a $10 million bond. I did ask Jeff Lindsay, Linda Stanley, and Mark Hurlbert for these items in court just after Judge Murphy left the bench to go to his chambers. These prosecutors refused and advised me that I had to get a court order. In front of the prosecutors, I asked Judge Murphy's clerk if she would please ask the court to reconvene to resolve the issue. The prosecutors quickly gathered their material.
So what she's doing now is they had a hearing, and then she wanted certain things returned to Barry. But the court had already rested. Like, the judge was gone. He's gone back into chambers. And she says, well, I asked the clerk, can we have court reconvene so I can ask the judge for these items, his truck and his license, to be returned? And the prosecutors got up and started leaving, and they scurried out saying, file a motion for it if that's what you want, because this wasn't on the docket to be heard today or that day. So the clerk had said, like, well, let me check. And as she's gone back to check, the prosecution packed up their stuff and was as she calls, scurrying out of the courtroom. Linda Stanley happened to still be there when the clerk came back, and the clerk asks her, you know, like, can we hear this? Because she wants to hear this today. And Linda Stanley said, no, file a motion, which is the way it should have been done. But Iris Eaton here, thinking that she is the queen of something, demanded that it be heard right now, even without her filing a motion or anything. And she figured that, you know, certain laws don't apply to her or to Barry, and that she should get what she wants all the time. And I am so happy that this went the way it did today, because this woman, like I said, I'm going to skip through a lot of this because she's just annoying. If you do want to watch the whole thing, you guys, I will have the link to this in the description. Head on over to Kurt's channel and check it out. And he gives a lot of commentary at the end also. So
materials and scurried out of the courtroom before the clerk could ask the judge, in order to force Mr. Morphew to have to file a written motion. The clerk came out, and Linda Stanley was still in the threshold, running out of the courtroom between the hallway and the courtroom, when the clerk asked her, Ms. Stanley, will you turn over Mr. Morphew's truck and his driver's license without a court order? And Linda Stanley said no, and walked out of the courtroom. The clerk then indicated we would have to file a motion. So we had to file a motion, which we did 3 days later on September 20th, 2021. And
blah, blah, blah.
Because they would be able to prosecute Mr. Morphew otherwise. But what they have failed to do 5 months after we filed this motion was explain how each and every one of the 97 items are fruit of or connected to criminal activity. Why they need each and every one of the items. In our opinion, they have defaulted their right at this point to object. Their objection is without any legal reasoning and more of their bad faith and punishing conduct.
Oh, Lady D, wait, it gets better. Like I said, I'm just going to skip through some of this because she goes on, as you can see, she goes on and on and on and on and on. So we're going to skip through a lot of it. It's just a lot of repetitive stuff. She keeps bringing up what happened in court before, about poor Barry Morphew and having to keep coming back and forth to court and this and that. And they didn't have the evidence and they arrested him falsely. And it just goes on and on. So I'm just going to skip through some of this, show you bits and pieces. If you want to watch the whole thing, like I said, I'll put the link in the description below. You can go and listen to it all if you can stomach it.
And no, the court did find that they didn't act in bad faith when they dismissed the case without prejudice 9 days before 1,000 jurors were summoned to come to trial. That is because they convinced this court they suddenly needed to find Suzanne. It was their ethical duty, and that they were, as they say on April 19th, 2022, close to discovering the victim's body. Again, now in their pleading, these prosecutors are trying to convince you of some notion of some made-up Stanley law and standard that they can hold Barry Morphew's property ad infinitum. As they stated in paragraph 11, that if Barry was never arrested, he could never get his property back. They asserted that they don't know whether any of the items are relevant, and they may not have a, quote, inkling whether these 97 items are relevant to illegal is because they made misrepresentations to the court, violated court orders and discovery rules, and why they were forced to
And here we go again. Now she's going over how they did all these discoveries and Brady violations, blah, blah, blah. So the judge removed 11 of their expert witnesses. Like, that has no bearing on what's supposed to be happening today. That's why I'm skipping through a lot of this, you guys, because it's just verbal vomit at this point.
Dismiss this case. That is why their bad faith and misconduct should be considered when considering their baseless arguments. So let's look at the case like the way they want to look at it. Before Barry was arrested.
Oh,
well,
God.
Not withheld evidence of innocence, misstated facts, and not asserted a theory of murder without any evidence. In that April 8th, 2021 order, the court says, most obvious and egregious violation, the code in and around Salida, with no results, searching the mountains, the flatterlands, testing multiple pieces of evidence. Also before Mr. Morphew was violated the pretrial publicity order and committed a pattern of reckless discovery violations, all actions to shortcut If they said, we don't have any inkling.
Like I said, you guys, it's verbal diarrhea. Just like Rosie just said, verbal diarrhea. She keeps going over and over and over and over and over what happened in the previous case. That's why I'm skipping through it the way I am. I just can't listen to this woman. She makes me sick.
Of what is relevant, no inkling of what's connected to an illegal criminal activity. And if you did sign it, just a thumb drive. Number 20, financial documents from various for each and every one of these items that they have had for 2.5 years, when they have not articulated at all why or how they need them. Many of these 97 items have been and can be photographed or downloaded, Your Honor. Just looking at the list. Number 1, a thumb drive. Number 20, financial documents from Barry Morphew's truck that includes titles and tax documents that have stymied Barry Morphew's ability to conduct business and personal action. Number 32, the HP laptop. It's already been downloaded, Your Honor. Number 33, a Mac laptop, downloaded already. Number 30.
Watch Kurt, like he's howling at this too. It's like, you are a criminal defense lawyer and you know that they took certain things off those items. They have to keep those items because there may be other things that they missed before that are on those laptops or drives or whatever. Like I don't know, she's on some kind of cheap drugs or something. I don't know.
An Apple iPad, already downloaded. Number 35, Kindle, already downloaded. Number 36, a letter from Barry to Suzanne. They already have taken a photograph of it. Various journals and notebooks and letters. Number 43, tax documents needed for Barry to file his taxes and re-enter society. Number 45, 46, and 49, documents, receipts. Number 53. Number 58,
he's getting irritated.
Portrait. What is it about this family portrait that will lead them to finding Suzanne? 81, miscellaneous paperwork from gun safe. 94, tax documents. Some items don't make any sense at all. Number 26, AirPods. Number 31, a suitcase. What about these items that were seized a year after Suzanne went missing and 2.5 years later, when Barry was arrested, are linked to criminal activity? How about number 22, 3, 23, 24, 25 trail cameras, number 37 to 39 trail cameras that had SD cards that they can keep the SD cards. Give the cameras back. The court might know that Barry is a hunter, and right now he has authority to use a bow and an arrow. But he shares ownership of many of the firearms with his daughter, Mallory Morphew, and many of the guns that were seized in their gun safe. They can swab them. But this is the truth, Your Honor. They're not even evidence. Because Mr. Hurlburt said on March 30th, 2022, in response.
See, and she's saying, okay, so they're keeping all his guns and everything else, and they're saying that these aren't even evidence. Well, how do you know? They're not going to know if this is evidence or not until they find Suzanne's body. If they find Suzanne's body and there's a gunshot, they have to have his guns to see if they match, right? Whether he's part owner with his daughter or not, they've got to have those guns there to test to see if any of those guns were used, if there's a gunshot wound on Suzanne's body. So, I mean, claiming she's a self-proclaimed as smart as she is, she knows this already. And if she doesn't, well, there's serious issues.
To Judge Lama's question about whether or not firearms are essential evidence in this case, Mr. Hurlburt says, Judge, I think the fact that we did not find any blood.
Look at Kurt. Look at his he's not impressed.
Anywhere in the house. A knife wound would have, or knife murders. I've seen gun murders. There's always blood in the house. There was nothing found in the house.
There's nothing found in the house because maybe he didn't murder her in the house. Like, are you that naive, woman? Just because there's no blood in the house doesn't mean that he didn't murder her outside of the house. And those guns still could have been used. Dumbass.
There's no blood found in the house. And I'm reading from this transcript right here. So what about the gun that Mr. Morphew bought after Suzanne went missing? Number 28, the one he bought at Salida Gun Shop. What about all the arrows? Number 8, number 30, number 59, number 97. There's no blood. It's already been confessed. His property is sentimental, as he is the one whose wife that he loves.
Huh. His guns are sentimental. Look at AK again. His guns are sentimental. Well, I think that a living human being, namely your wife, would be more sentimental, and that would take precedent over you getting guns back that you can't even use and are not by court order. You're not even supposed to have them in your possession.
Went
That he
missing.
killed, bitch.
It is necessary for him to conduct his personal and professional business and important to his daughters. And much of it is very expensive and could assist Barry in getting some of the financial damage caused by the prosecution's misconduct.
Okay, so you see what she says there? He needs these guns. He's an avid hunter, blah, 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 blah. Okay, so now he wants to sell them to regain money that it cost him for this trial. Which is it? Does he want them? She just said he wants them back as their sentimental value. And then she turns around and shoots herself in the foot, no pun intended, by saying he could sell them to recoup some money that he lost during this trial. So your argument is he wants them back because of the sentimental value, but then you say he wants to sell them. Like, what? What? Did you think about what you're saying, lady, before you say it? Ugh.
And this does not even take into consideration, Your Honor, how they have treated Barry's property. They used substantial permanent marker on his cars, on his couches in his home and furniture, and tore out the Range Rover and truck computers and returned them both laying on the front seat in June 2020 without putting them back in place, costing Barry Morphew nearly $15,000 to repair. The court should hold to the standard as set. Take into account the prosecution's many false assertions before Mr. Morphew's arrest during the pendency of the case and the false assertions made to dismiss this case. If the court does not grant our request because they defaulted in not answering to their need for the 97 items after we filed our motion on May 26, 2022, we ask the court not extend this hearing as an additional cost to Mr. Morphew and hold the prosecution to identify today why each and every single one of the 97 items are linked to criminal activity and cannot be returned to Mr. Morphew in violation of his constitutional rights. Mr. Morphew's property has been seized and held for 2.5 years. They've had plenty of time. And 6 months after they dismissed the case because of their misconduct and false claims that they were going to find her body when the snow melted.
What about the probation?
They're holding his property without due process of law in violation of the United States Constitution. And they all should be ordered to be returned. Thank you for giving me that time, Your Honor.
You would limit your response to the issue before the court.
Lady D says, what? He's going hunting again? Who this time? Yeah, exactly right. Who's he going to hunt this time? He is allowed apparently to use his crossbow and arrows. But to me, it's like, well, you can still do damage with that. You can still put a tip dart on that and render someone incapable of moving, right? Tranquilizer darts could be put on the end of one of those and fired, but he is allowed to use his crossbow, but not any of the guns. So this now is, the state is going to get up and we'll just, he seems a little out of sorts when he's responding. We don't have to hear everything he says. Like I said, if you guys want to hear the full video, you can go to the link that I will have in the description and you can go and listen to it all. I find he's very flustered. He trips over his words and stuff like that, but he does give good reasoning why, etc. This evidence still has to be kept. He states, just to give an overall, that it's an ongoing trial. It was dismissed without prejudice. And by what I get from this is they will be bringing charges in the future. So.
Absolutely. Absolutely. I had forgotten sometimes things can go off the rails into rehashing issues that really are not relevant. Judge.
See his first statement, rehashing elements that are things that aren't even relevant. Like she went through for a good, 30 minutes of crying about what happened in the last court case. Okay. So he made it a point of saying this was not the time or the place to rehash that stuff and to bring it into this motion, but she did, right? He's going to be brief, basically stick to the points, why they're keeping it, etc.
The standard is pretty simple. I mean, the standard cited by the defense is not the standard.
Watch Iris Eaton up here.
Needs to
She
follow.
gets peeved
Every
off.
single one of the cases cited by the defense are cases that were already done. For whatever reason, not guilty by trial or pleas. That is not the posture of this case. And even in the cases cited by the defense, I think they made this distinction, even though it was not specifically outlined. In People versus White, 701 Pacific 2nd, 870, the Colorado Court of Appeals case from 1985, the court stated that the evidence they were talking about was evidence against which no government claim lies. Then People versus Hargrave, 179 Pacific 3rd.
Okay, so what he's doing here, you guys, we didn't hear a lot about this, even in the full version without stopping in that. She cited a couple cases where she said, well, in these cases, they're done now and everybody got their property back. Why isn't Barry Morphew? Well, because the cases that she cited, either there was a verdict handed down or they were totally dismissed. They weren't dismissed without prejudice. They were dismissed with prejudice, which means they could not be tried again. So anything that is at the end of a trial or in the middle of a trial, if anything is dismissed with prejudice, means that the case is done. It can never be tried again. So they got to give that evidence back or property back that they seize. Or when there's a verdict that's been reached, then the property can be returned afterwards. But in this case, the case was dismissed without prejudice and it's still an ongoing investigation. That's why they are keeping the evidence. This is what he's getting to. He's talking about, we didn't hear a lot about it, but he's talking about the cases that Iris Eaton cited in her argument, lost in all the other verbal diarrhea from what's already been decided. She tries to throw in these cases where people got their property returned, but those cases were settled. They were done, finished. This one is not. This is ongoing, but she tried to throw that in there. And now he's citing those cases. He's reading them and saying these cases are not ongoing. These are already done and decided. So why she's trying to use that is beyond him.
226, Colorado Court of Appeals, 2007. They talk about when the need for the property seized when a case has ended. That's not this case at this point, Your Honor. And in People versus Small, 631 Pacific 2nd, 148, Colorado Supreme Court from 1981, they talk about when a case has been taken dismissed without prejudice, you take it back to the same condition as before the case was filed. So despite Ms. Econ's protestation,
watch her face. I think he changes the setting again on this, but watch her face when he's putting all her claims out to garbage.
Are at the place, whereas before the defendant was arrested on this case. So what does that mean? That means, Judge, the question is only, do the people have a need and an interest in these items? And yes, we do have that interest. We have the interest to preserve evidence for future prosecution, whether that's for future testing or future entry into trial. We're not destroying the evidence. Which was some of the issues with the cases cited by the defense. At times there was guns or things like that that was going to be destroyed. In fact, the sheriff's office wants to keep this. They need to keep this. We're going to be preserving. And specifically, I'll say, yeah, we don't know what we need it for at this time, Your Honor, and that is something that is okay after we receive property. There is nothing that says that we cannot do that. If we give away the guns and we find Suzanne's body and there's a bullet in it, potentially we would need to not more than just take fingerprints of it, not more than swab, but actually fire the gun to test it forensic. At the time, absolutely, I said I didn't believe that she'd been shot, but you know what, Judge, I've been wrong before. And I hate to give away a murder weapon. because I was wrong months before we knew what all the evidence was. The computers and the phones, which has probably already been replaced, frankly. Again, if we release to the defendant, maybe there's new technologies. They'll be able to get at deleted information that maybe Suzanne had written on these computers. And then the clothes too, Judge. It's highly unlikely that, again, anyone other than the defendant had murdered his wife. But if it turns out there was somebody else, these clothes that the defense is asking for potentially DNA purposes. This court knows it. He knows it more than anybody, certainly knows it more than anybody in this district and probably anybody in the state. After just recently presiding over the case of People versus Alan Phillips, where court heard evidence of things that law enforcement thought was not important back in the day, suddenly became important and suddenly became key.
You watch her, she's like taking notes like crazy, and the shaking of her head and stuff like this. It gets better, you guys.
So, Judge, that is why we need these. We need to keep this evidence. And as I mentioned before, yeah, we did give this pass. When they gave us something specific and said, "Hey, look," they filed a motion. They had to file the motion. Tom's right. They had to file the motion. But we did get that back. If she had said something to me like, "Hey, we need X," we need the tax documents, we would have taken a look at it. But instead, the email we got from her was something 4 general items, which I included in this, included as an exhibit in our response. And Judge, as far as the guns, the defendant can't get those guns back. The development that has actually happened since the defense motion and since our response was that he pled guilty to felony voter fraud as a part of a deferred judgment sentence. And under federal law, under federal law, prohibits him from owning or possessing a firearm, at least until the deferred judgment sentence is over. So at this point, the sheriff's office cannot give back those firearms. Judge, the finding of Suzanne is not, our filing of charges coming.
You see what Kurt did there? Okay. Let me just see if I can. Oops, wait, we're not there yet. Let me just see if I can get it. Where did it go? He showed you the cliff where he thinks Barry tossed something.
It was not predicated on the finding of Suzanne. The finding of Suzanne is not a standard for giving evidence back on an open case or not giving evidence back on an open case. And yes, law enforcement has been searching diligently for Ms. Morphew. We thought back in May that we were close, that it was going to be soon that we were going to find Suzanne Morphew. Obviously, we were wrong. But the law enforcement is still looking, still following up. This is
the voter card that he
still looking for
pled guilty to, where he signed it.
And the defendant. Judge, ultimately, there's only one reason to keep this evidence.
Look at her face.
The Chaffee County Sheriff's evidence room.
Look at Kurt mocking her.
And there are cases coming in every single day where evidence is based on the evidence room is needed.
Kurt is really a thorn in her side. Like she does not like Kurt at all, because you're going to see AK is going to have a lot of stuff that's going to be coming out regarding this case that the prosecution, I think it's going to help. And where the prosecution didn't have endless time to go over and really with a fine-tooth comb go over certain things, AK has. Okay. He's very knowledgeable in what he's doing. And I think that Iris Eaton knows it. She has a hate on for Kurt like you would not believe. And the feeling's mutual, believe me.
You cannot just keep evidence, despite somebody. Cannot just keep evidence for an improper purpose.
He will, Rosie. He's going to be coming out with a series of stuff that he thinks is important in the case, and he's going to be turning it all over. And hopefully it's going to light a fire under their ass to get going on this again, because what he has is going to be good stuff.
Because he does not have the luxury of having space in his evidence locker. The only reason why he would keep this evidence is the reason why for future prosecution on an open case, which is what this is. It is an open case.
She's going, nope. Kurt's going, yep.
In its entirety. Setting aside
me too,
some
again.
of the irrelevant
And Kurt rolls his eyes.
irrelevant statements from the defense, relitigating things that were not relevant to this. The standard is pretty simple. This is an open case that's cited by the defense. Standard they cited are only for closed cases where it is over. And Judge, this evidence could become, could very well become important in the case down the line against the defense. So, Your Honor, this point we ask you to deny the defense motion.
All right, the court's going to find that.
This is what, watch her face, you guys. Like, she is pissed off. And yes, it is going to be good, Rosie. It is going to be good. But if you watch Kurt and the way he mocks her, and it's like, ooh, it's hilarious. Okay, so let's listen to the judge.
The evidence received pursuant to
Watch
a valid
her
search
face
warrant where probable
Kurt.
cause was found.
Oh, on go the
by
glasses.
prior judges in this case, and it's going to deny the motion for return of property at this time, and find that it is being lawfully held for the purposes of possible future prosecution based on the facts of the case.
She is
This court will
mad.
not be, unless something else happens, will not be presiding over the case in the future, because I have mandatory retirement facing me in the next 2 weeks. So another judge will be assigned to hear the case unless I come back in a capacity other than the state judge, possibly a senior judge, which we'll see how that happens. What happens with that? So motion is denied. Thank you very much for your time, everyone. We'll be in recess.
Thank you, Your Honor.
She is pissed off. So, with that, you guys, Iris Eaton was finally put in her place. It was all denied. He is not getting his property back. And I do believe that there's going to be stuff that comes in to the sheriff's office that is going to relight this case. So what do you guys think? So next up, we are going to go over the Debbie Collier case, because there's new stuff that has also come out on that. What do you guys think? I'm not getting much chatting from you guys, so I don't know if my chat is frozen or what. I'm rubbing my hands with glee. Okay, so let's jump into the Debbie Collier case. Let me just bring this up. This is from Fox News. I think I can take this off now. It's giving me a headache. Okay, so this is from Fox News. Debbie Collier case. You guys know I did a read on this case also. This came out, I believe, yesterday or 2 days ago. Debbie Collier case. Investigators consider Georgia woman's death may not be a homicide. Debbie Collier was found dead, naked, and partially burned on September 11th. Georgia investigators have begun exploring the possibility that a disturbing death of Athens office manager Debbie Collier may not have been a homicide as initially suspected, according to law enforcement. They have no evidence linking several of the key people close to Collier, including her husband, daughter, and daughter's boyfriend, to locations anywhere near the crime scene between her disappearance on September 10th and the discovery of her remains the following day, according to two sources with knowledge of the investigation. And evidence at the scene suggests that her death could have been accidental or suicide, sources said. I don't understand this at all. How can somebody found in the shape that she was and burned, that's not how somebody commits suicide. They do it by the means that's going to be less painful for them. I can't see somebody wanting to strip themselves down, especially, any human, particularly women, wanting to be found naked. Number one. Number two, partially burnt. I just don't get it. Collier was last seen at a Family Dollar store on September 10th, purchasing several items that were found burned near her remains. So why would she go to a store, buy stuff just to burn it? You know what I mean? She also stopped by a Chick-fil-A restaurant beforehand. So this is her here. Collier was found dead and naked on September 11th at Chattahoochee, Oconee National Forest, south of Clayton, a 90-minute drive from her home. Her husband, Stephen Collier, reported her missing around 6 p.m. the day earlier. She was discovered a few feet downhill from the site of a small fire with burns on her stomach, soot in her nostrils, and clutching a small tree. There is no way that somebody would try and off themselves in this manner and in this state. Nobody wants to be found naked, right? Big red flag right there for me. When Fox Digital News visited the scene earlier this month, it was evident that at the heart of the burn marks, there were no signs that a wood-fueled fire had been constructed, although several items she was carrying were found scorched on the ground, including a blue tarp she had just purchased and small remnants of the Georgia Bulldogs jersey she was last seen wearing. So did somebody just try to burn her stuff? I don't know. The missing person report came after she sent a bizarre Venmo payment to her daughter, Amanda Bearden, of almost $2,400, along with the cryptic message, "They are not going to let me go. Love you. There is a key to the house in the blue flower pot by the door." Well, it's not like she lived alone, right? She has a husband. So why would telling her about a key by the flower pot matter? The husband would be able to open the door. So that is kind of what's going on. You know what I mean? Like, it doesn't make any sense to me why she would say there's a key in the flower pot. She didn't live alone. Like, you would expect that from somebody who lived alone, but she had a husband. So why would that be one of the final things she would want to say to her daughter? There's a key in the flower pot. Doesn't make any sense. The sum Bearden received the day her mother went missing is very close to the amount Bearden's live-in boyfriend, Andrew, owed in probation fines, a source told Fox Digital News. The math, they said, could be thrown off slightly by additional fees. 2 days before Collier's disappearance, her daughter, Amanda, and her boyfriend, Andrew, moved back to Athens from Maryland, where they had been living with her brother. Gearage told Fox Digital that the couple had no involvement in the crime and that they were scared themselves, sleeping behind barricaded doors as the case remained unsolved. Authorities have not yet released the autopsy report, toxicology results, or her official cause and manner of death. On Friday, the local radio station WCHM reported that an unnamed ranking member of the Habersham County Sheriff's Office said it would be a good assumption the detectives were no longer focused on Collier's immediate family in connection with the investigation. John Kelly, a criminal profile and psychoanalyst who has been following the case, said that there are a few questions he'd still like to have answered. Why'd she drive up there? Why try to pull herself up after she'd fallen down a hill and in through woods? She looked like she was getting ready to go tailgating, dressed up to have fun, not kill herself. Also, where's that money? What happened to that money? What happened to that money that was sent by Venmo to the daughter? What was on the devices? Anyone with information on Collier's case is asked to contact the Habersham Sheriff's Investigations. So that's the new information that's come out there. And it's like, wait a minute. There's so many things. Like, why would you go and purchase stuff just to burn it? I agree. It sounded like some stuff that was being purchased for a tailgate party for this football game. She had her jersey on. Why is just her stomach burned? Why was she grasping a tree? What actually killed her? Why was she down in that area 90 minutes from home? There are still so many unanswered questions. And I can't see at this point anything other than a homicide. This is not the way somebody would off themselves, let alone want to be found naked. So, I don't know, you guys. I just bring you what I have found, and that's what we have found. So, with that being said, I don't know where it's going to go from there. We have nothing new on the Quinton Simon case. Protesters are outside of the home watching their every move. We did see press releases where the mother and grandmother spoke to media, which I don't buy for a minute. I don't believe that they're going to find Quinton in the landfill. You guys, we're moving on to that one. I believe that he was disposed of elsewhere, and it's a big red flag. I've said it since the beginning. And there's things being talked about within certain agencies that it could very well be that he is not in that landfill. I've said that from day one. I believe that that was a distraction. I do believe that they have her on CCTV camera throwing a garbage bag of something into a dumpster. I believe that that could be evidence. It could be a blanket. It could be because I got something about a blanket and a car, a toy car. He showed me that. Quinton showed me that, a blanket and a toy car. So depending on how they did take his life, there could have been other evidence that DNA or blood or something got on other evidence, and that was all collected up, put into a garbage bag, and tossed in that dumpster. I don't believe it was Quinton. I don't believe it was Quinton. That's just my opinion. I got to go by what my cards are telling me. And my cards are telling me that he's not there. Could I be wrong? I could be. Children are very hard to do readings on because they don't think the same way us adults would think. So when he's showing me stuff or when things are coming out, I'm processing it as an adult, whereas he's trying to show me as a child. So something he's showing me could mean something different than the way I'm interpreting it. But when I look on my cards, and especially the very first read, my Ancestor cards, tells a whole different story than what's being projected. Now with the grandmother coming out and saying that she admitted to killing him, throwing him in the dumpster, to me, if that's true, that's enough to arrest her right there. He is missing. They're searching the landfill. Are they not bringing those charges yet because they think that there's a good possibility that that's not what happened? And if they arrest her under the assumption that that's what she did and they got it wrong, their case is gone, right? Think about that. If they believed that that is what she did, then they would have arrested her. They are searching that landfill in the hopes to find Quinton. But I don't think that's going to happen. I think what was thrown away in those bags was other evidence, other items. I don't think it was him. And I think it happened a lot earlier than what is being said. And I don't think that the boyfriend actually physically seen Quinton in that playpen when he left for work. Another question I have that still has not been answered to this day is, if he left for work at 6 a.m., why was he back at the house at 9? Does he only work 3 hours a day? Why was he back at the house? And why did he pack up and hightail it out of there when this broke? Why would he leave his daughter in their hands and take off? Right? There was things that were said that, oh, well, he thought she's crazy and this and that, and he thinks that she did something to Quinton. Then why would you hightail it out of there without your daughter? Think about this, you guys. Like I said, there are things that I have come to learn that I cannot share yet. But I'm telling you little tidbits. Think, let it sink in and think. Why would he leave his daughter there and hightail it out of town if he thought Liani did something to Quinton by herself? Right? There's a reason why she hasn't been charged yet, and I do believe that they may now be listening to my read. I'm going to say that quickly. There are, I'm not going to say which agency close to this case may or may not be directly involved with it, but are a legitimate, could be search, could be FBI, could be police, it could be whatever, that I've been in contact with that has said my read is 100% on the mark. But I can't elaborate. I've been hoping by now that I would be able to break that to you guys. But when I get notification from them saying my read was 100% on, that's how I can say, don't hold all your eggs in one basket that Quinton is in that landfill, because I don't believe he is. I believe there could be evidence there, but I don't believe he is there. So with that being said, I've got to be very careful with updated reads. That's why I had to wait to do the updated read. And I'm going to be doing another one. I'm not going to elaborate on certain things if certain things are said in the read, because it will come out. I've been doing morning polls, and there is information that I already know is true that has come out. It's just I can't focus on that and bring that out, because it very possibly is a major thing in the investigation. So with me getting clarification from one of the agencies involved saying that my read was smack on, I know I'm on the right track. And like I said, you guys, it's very hard to read children. And yes, there are certain things. Thank you, Rosie. There are certain things to protect the integrity of the investigation that I cannot release right now. It will all be released at some point, but I just can't do it right now. But I did give you a few things to think about, okay? So with that being said, you guys, I'm going to wrap this up. Please watch my community tab for the updates on what happens in the Lori Vallow hearing today. We're going to know if her case is going to be stayed again, or if she is going to be going forward. Once I got that information, I will put it in the community tab. So please keep an eye there. If you're not subscribed, subscribe. hit the notification bell so you're made aware when things do pop off. Okay, I will jump on. Like I said, please keep an eye on that community tab on my page. That's where I'm going to put the updated information and paperwork. I want to get a copy of the arrest affidavit for the little boy, and I want to get the information regarding what's happened with Lori Vallow today. So that will all be in my community tab. Now, the arrest affidavit for the little boy that was found in the suitcase, I may jump on and do another live and go over it. I know I've got quite a few subscribers that like me reading it. I know I have 2 that are blind, so they do listen, so they can't read the documents. And I want to make sure everybody gets a fair shot at seeing and hearing and everything. So if it's not overly long, I should still do it anyway and go through the arrest affidavit regarding baby Cairo. So, and that's the little boy that was found in the Las Vegas suitcase back in April. There's been 1 arrest. For those of you just joining, there's been 1 arrest, and there is a murder warrant arrest out for his mother. 1 has already been arrested. They are both females. So there could be some kind of relationship there somehow, some way. I'll know more when I see the arrest affidavit. So I am going to be going and finding that now, and we will go over that. So yes, thank you. Thank you, Rosie, for being here and keeping things on point. My mod, Rosie is like family to me. So thank you, thank you, thank you so much, Rosie, for being here. You're very welcome, Cece. So again, you guys, there is also a little heart that you will see down below the video if you enjoy what I bring. And regarding these cases, you can donate to the channel there. You can go do super chat, super stickers. My PayPal is also going to be in the description. If anybody wants to do a donation, it's always accepted. And I thank you very much for those. It helps me keep going here and bringing you guys this stuff. Also, there is a link in the description of every video to my merch store. If you want to go and check out the new stuff that is there for winter, fall, winter. Everything is up now on my store. So with that being said, thank you guys so much for being here. I appreciate each and every one of you for supporting the channel and for watching. So like I said, please keep an eye on that community tab because I will be posting there also. Okay, you guys, until the next time, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.